Just briefly, here are some of the key legal developments within the UK consequent upon Brexit and the entry into effect of the withdrawal agreement. There are three key points here. First, the provisions for legal continuity at the end of the transition period. Second, the provisions to facilitate future UK relationships with other countries and with the EU. And third, the provisions about the devolved, Northern Ireland, Scotland and Wales. On the first, the Withdrawal Act will repeal the European Communities Act of 1972, changing the way that EU law takes effect in UK law. It didn't do that on Brexit Day because of the amendment introduced by the Withdrawal Agreement Act 2020 to provide continuity during the transitional period to the end of December 2020. When it comes into force, the European Union Withdrawal Act 2018 will provide legal continuity, enabling pre-existing EU law to become a new source of UK law. The Act gives powers to change that retained EU law by ministerial action without the need for legislation and parliamentary scrutiny and oversight. On the second, other legislation includes the Trade Bill, which failed to be adopted by the House of Lords in January 2019. Peers voted by 243 to 208 to shelve the Trade Bill amid concerns that ministers refused to provide enough detail over its proposed future agreements with the EU, but also, crucially, with other countries like the USA or Canada. Among their complaints is that the government has failed to make guarantees on food safety and animal welfare in its hoped-for future trading regimes. As at November 2020, it is still in the House of Lords. Constitutionally, the government is able to sign and ratify international agreements with minimum reference to Parliament. And the UK has already agreed trade agreements with a number of countries, which will enter into effect in January 2021. In general, most of these roll over the arrangements that the UK had when it was an EU member state. Normally, however, legislation would be required to implement those treaties into domestic law. The Trade Bill is designed to shortcut this process and authorise the government to implement new agreements directly by executive act. The shift of power from Parliament to government is one of the key features of the UK's post-Brexit, post-transition constitution. This is also the case for the Immigration and Social Security Coordination EU Withdrawal Act 2020. The Act repeals EU law relating to free movement of people and places EEA nationals and their families under UK immigration control after Brexit and after the end of transition, while protecting the status of Irish citizens in UK immigration law after the end of transition. The Act gives the government powers to amend retained EU law relating to social security coordination to enable post-Brexit policy change. There is also a raft of legislation on specifics, such as, just to give one example, the Act on EEA and Switzerland healthcare arrangements. And there is huge amounts already of secondary legislation which will come into effect at the end of transition. Parliamentary scrutiny of this delegated legislation has been extremely difficult to secure in practice. Turning now to the devolved, Northern Ireland, Scotland and Wales. Responsibility for a number of current EU competencies like public health or environmental protection is devolved to the separate jurisdictions of England, Scotland, Wales and Northern Ireland. At the end of transition, powers currently held at EU level will be repatriated, but the question of how these competencies will be redistributed back to the devolved level remains disputed. The UK's constitutional settlement has been described as evolving, and certainly the relationships between Westminster and the governments in Cardiff, Edinburgh and Stormont are quite different now from when the UK joined the then EEC in the 1970s. Key issues here concern restoration of EU-level powers to the devolved jurisdictions. If each jurisdiction gains significant powers, for instance in public health fields, regulatory deviation may jeopardise the UK's internal market for products. While this may or may not be a problem internally, it will certainly make it more difficult for the UK to offer access to the whole of its market when it negotiates trade agreements with the EU or with other trading blocs or countries. The UK economy may also be negatively affected by being divided up. The European Union Withdrawal Act 2018 provides that current restrictions on devolved competence, which arise because of the UK's obligations to comply with EU law, will be removed by the Act. However, there is a controversial exception to this default of devolved powers back to the devolved administrations, the European Union Withdrawal Act 2018, Section 12. This comes under a power in the Act for UK ministers to freeze, by regulation, aspects of existing EU law, and with it, the constraints on competence. The intention then is to subsequently introduce new UK-wide legislative frameworks in these areas. These areas have been identified following policy-specific intergovernmental deep dives between officials. These are called the frameworks analysis. At both the stage of making the freezing regulations and the future common frameworks, there is a political undertaking by the UK government to not normally proceed without the consent of the devolved jurisdictions. And that is called the Intergovernmental Agreement on the EU Withdrawal Bill and the Establishment of Common Frameworks, and that was agreed on the 24th of April 2018. However, there is a significant concern that these assurances designed to protect the powers of the devolved jurisdictions do not, in fact, attract any enforceability through judicial process. There is so much concern that the Parliament in Scotland refused to give its legislative consent to the Withdrawal Act. The lack of legal enforceability of the so-called Sewell Convention, the convention that Westminster will not normally legislate in devolved areas without devolved consent, was confirmed in the Miller 1 judgment. But the legal constitutional landscape is more than usually fluid and uncertain here. Scotland did not consent to the devolution parts of the EU Withdrawal Act. The Supreme Court ruled on Scotland's UK withdrawal from the European Union Legal Continuity Scotland Bill, which went through the Scottish parliamentary process but did not receive royal assent. This bill's aim was to secure continuity of EU law in Scotland, much as the EU Withdrawal Act 2018 does for the UK. But it also seeks to place on a legislative footing the Scottish government's understanding of its devolved powers and how Brexit affects those. The UK withdrawal from the European Union Legal Continuity Scotland Bill, a reference by the Attorney General and the Advocate General for Scotland, decided by the UK Supreme Court in the 13th of December 2018, concerns this issue. It was decided under the Supreme Court's jurisdiction in Section 33(1) of the Scotland Act, which provides that the Advocate General, the Lord Advocate, or the Attorney General may refer the question of whether a bill or a provision of a bill would be with the legislative competence of the Parliament to the Supreme Court for a decision. The Supreme Court held that the bill as a whole is not out of the competence of the Scottish Parliament. However, the court also considered that Section 17 would be outside the legislative competence of the Parliament because it would modify the Scotland Act. This is because the UK Parliament has the power to authorise ministers to make subordinate legislation, but the effect of Section 17 would be to make the legal effect of such subordinate legislation conditional upon the consent of the Scottish ministers. The imposition of this condition would be inconsistent with the recognition in the Scotland Act, Section 28, subsection 7, subparagraph 7, that the UK Parliament has unqualified legislative power in Scotland. The court concluded that several provisions of the Scottish Bill, in whole or in part, amount to modifications of the UK Withdrawal Act, and as such, these would be outside the competence of the Scottish Parliament. A similar act for Wales was repealed following a political settlement, the law derived from the European Union Wales Act 2018. Back to Steve Pear's EU law analysis blog. This time it's Alan Reid, who's at Sheffield Hallam University. The Scottish courts and the English High Court received applications from aggrieved members of the public, legal experts and politicians extremely worried about Prime Minister Johnson's decision to prorogue Parliament for 5 weeks through September and October 2019 at a time of immense constitutional upheaval and crisis, given the impending deadline of the 31st of October 2019 and a no-deal Brexit. At first instance in Scotland, the petitioners in the Cherry Miller 2 case lost. The court held that prorogation was a matter of high politics, not law, and thus beyond the purview of the courts. Similar cases in the English High Court and the High Court of Northern Ireland took the same view. On appeal in Scotland, the inner house of the Court of Session unanimously overturned the opinion of Lord Doherty in the lower outer house. The egregious nature of the Prime Minister's decision meant that the matter was justiciable. It was a legal question, the question of an improper use of the royal prerogative. The Supreme Court essentially agreed. In a unanimous decision, the UK Supreme Court held that the Prime Minister Johnson's prorogation of Parliament was unlawful and thus a legal nullity and of no legal effect. See paragraph 69 of the judgment. The UK Parliament, having been put illegally to sleep, got back to work the following day. It was important that this was a unanimous judgment of 11, the largest possible configuration of the UK Supreme Court, and that the judgment is clear, short, and relatively simple. Commentators have pointed out that the Supreme Court is transforming itself into a constitutional court. A defining feature of any constitutional court is that it decides decidedly political cases that deal with high politics and the inner workings of the constitution of that state. To that extent, the Supreme Court of the United Kingdom absolutely performed a constitutional court function in the Cherry Miller case. As already noted, the UK economy may be negatively affected if each UK jurisdiction gains significant powers, for instance, in public health fields. Regulatory deviations may jeopardise the UK's internal market for products if producers have to meet a dual regulatory burden in order to sell their products across the whole of the UK. The UK Internal Market Bill seeks to solve this problem. The bill is currently at the report stage in the House of Lords, where many amendments have been tabled. At the Commons stage, only government-backed amendments to the bill were adopted, which were mostly just correcting errors in the text, which has been introduced at high speed. There's a great blog by Professor Kenneth Armstrong and an explainer by the Institute for Government, on which I'm basing this part of the lecture. As introduced, the bill would give ministers power to amend how the UK implements the Northern Ireland Protocol, which would breach the withdrawal agreement. This was highly controversial in the House of Commons, evoking questions of whether the UK is a trustworthy signatory to international legal agreements. Following the threat of a rebellion from the Conservative backbenches, the government tabled an amendment which would give the House of Commons a vote on the date on which these provisions would come into effect, which was adopted. The bill is based on what it calls the market access principles, non-discrimination and mutual recognition. These sound like their counterparts in European Union law, but actually they're different for four main reasons, as Kenneth Armstrong explains. First, mutual recognition in the UK Internal Market Bill is really a country of origin principle. The power to regulate is given to the jurisdiction in which the product or service is produced or originates. So if a product is lawfully sold in England, any divergent regulatory requirements in Scotland would only be applicable to goods produced in Scotland. Second, under European Union law, the Cassis de Dijon case establishes a strong but rebuttable presumption that goods lawfully placed on the market in one member state should be allowed onto the markets of other member states. Under the Internal Market Bill, that presumption is much more difficult to rebut, only on grounds related to disease and pest control or the movement of unsafe food, a much narrower list of mandatory requirements, to use the EU law language, than in EU law. Third, unlike in EU law, under the UK Internal Market Bill, there is no proportionality test to balance the competing objectives of market access and protection of different regulatory choices. Fourth, the UK Internal Market Bill only prohibits measures that have a significant adverse effect on competition in the market. That is a higher threshold test than in EU law, where there is in effect no de minimis rule under the Dassonville case. But under the UK Internal Market Bill, once a measure is caught, there is only a limited set of legitimate reasons for the devolved UK jurisdictions to protect their rules. Public health is included, but not protection of the environment or of consumers. Kenneth Armstrong goes on in his blog to explain how these differences might make a difference to how the UK Internal Market Bill will affect the powers of the devolveds. In practice, the relative size of the English market is likely to exercise a constraining effect on the powers of the other devolved jurisdictions. The UK government's position is that the bill is necessary. The Scottish and Welsh governments would prefer an approach based on mutually agreed common frameworks in specific policy areas.